welcome Professor Luttenberger. I will make a short introduction for those of you who, those of our participants who yet have not had a chance to meet you. So Professor Axel Luttenberger teaches maritime law and commercial law at the Faculty of Maritime Studies in Rijeka. He also has a vast experience in private practice because he was employed in insurance business and as a legal attorney and legal advisor, and he also has experience in local government and public service. He was a city mayor of our town of Opatija, and he was also a member of Croatian Parliament. He's an author of 4 books and over 100 academic papers, and but today his main activities are teaching, right? So the topic of Professor Luttenberger's lecture is very interesting. We are moving away a bit from the traditional maritime law topics, and we'll deal with the criminal environmental maritime law. So please, the floor is yours.
Thank you, Adriana, for your introduction. Yesterday, we had a brilliant presentation about cybercrime. If I recall everything what Professor said, there is no universal definition about cybercrime. There is no good response of the government on the cybercrime. There is lack of awareness about the cybercrime. And it is a sophisticated crime, definitely, and connected with organized crime and a large amount of money. So today we will speak about environmental crimes, particularly about the crimes in marine environment. So, environmental crimes can be broadly defined as illegal acts that directly harm the environment. Why broadly? Because there is no good definition. Such offenses is a threat to environment and call for appropriate response and call for appropriate governance of the state. Often, they are perceived as victimless or incidental crimes, and they are very low on the rank of law enforcement priority list, and are commonly punished with low sanction, which are unclear and minor. My presentation deals with the main areas of environmental crimes. Then there is a part dealing with the response to the environmental crime. Afterwards, I will mention some sources of law, which is a normal thing to do in legal presentation. The regional sources of law of the European Union, few directives of the European Union and the Convention dealing with that subject matter. Then the new approaches towards criminalizing environmental harms, and then the question of security. So environmental crimes is connected with, obviously, with environmental security. And finally, a small case study about the environmental crimes in the Republic of Croatia. This almost the same situation is, and not a good situation, is in other European countries. While the definition of environmental crime is not universally agreed, it is often understood as a collective term to describe illegal, unlawful activities harming the environment, and secondly, benefiting individuals or groups. According to the European Commission definition, European crimes covers the breach of environmental legislation. So it is a crime by reference to other legislation and cause significant harm and risk to environment and human health. So the key word is significant harm. What is a significant harm? We can make an elaboration about that. So, in the theory, the main areas of the environmental crimes are illegal emission or discharge of substances into air, water, and soil. Water meaning sea, oceans. Trade of wildlife, trade of ozone-depleting substances, and shipment and or dumping of waste. Environmental crimes in real life is typically seen only as small infraction with fines or misdemeanors, fines or shorter term imprisonment, rather than, let's call it, a serious crime. On the other hand, environmental crime is highly lucrative. It is profitable as illegal drug trafficking, and it is a good business opportunity for organized crime, if I may call it, because in illegal drug trafficking, imprisonment is quite often, or you could go in jail in some cases for a long period of time, and here the risk is really high. So led by vast financial gains and facilitated by the low risk detention and scarce conviction rates, criminal networks and organized crime groups are becoming increasingly aware of environmental crimes. They are more aware than the general public. So they have more knowledge than the state on that particular issue. A person who commits environmental crime exploits, in fact, the lack of international consensus and the divergence of and various approaches of various states, of various countries. What may constitute a crime in one country, it is not a crime in another country. The capacity of government or the governance of the government varies from one country to another country. The Interpol General Assembly resolution states that there is a vital need for a global response in combating environmental crime. Unlike other known crimes, environmental crimes are aggravated through additional costs to future generations. So there are long-lasting impact on the society. And environmental enforcement challenges is determined by specific issues, lack of awareness or insufficient prioritization of environmental crimes, very low at the level of law enforcement, insufficient knowledge and practical experience, diverse investigative or inspection approach in different jurisdictions, and not appropriate knowledge on key legal concept considering the subject matter. And it needs definitely a multidisciplinary approach. Always when you need a multidisciplinary approach, you have a problem in implementation of this multidisciplinary approach. So here is a directive of the European Union, directive called on the protection of environmental through criminal law. You have a recital of Article 3. too many information on one slide, but the idea is that you see that there is a very comprehensive wording about environmental crime. Actually, it quotes that member states shall ensure that following conduct constitute a criminal offense when unlawful and committed intentionally or with at least serious negligence. Intentionally or at least serious negligence. And there is enumerating from A to discharge, emission of introduction of quantity of materials into C as well. Collection, transport of waste, shipment of waste, dangerous activity, the activity which are harming the quality of water, the things connected with nuclear materials and other hazardous and noxious substances, the destruction of protected area. We have natural parks in the marine area, trading of specimens in the protected area, deterioration of habitat, and ozone depleting substances. So it seems to be quite a good article, but it is. Actually, the list of environmental offenses that must be considered criminal offenses by member state if committed intentionally or serious negligence only. It must be pointed that the directive does not create a new list. So there is no new idea in that directive, because the existing law already provides this prohibition in various member states. It only set a minimum standard, which in real life is implemented in various states, and saying that member states could make a more stringent list. The second directive is on environmental liability with regarding the prevention and remedying of environmental damage. There are actually three categories of environmental damage under this convention: the damage to protected species and natural habitats, natural habitat in the marine area as well. Water damage, which is any damage that significantly adversely affects the ecological, chemical potential of a certain area, as well as land damage. So there are those two directives. And finally, in this part, there is a convention on the protection of environment through criminal law. It seems quite well. But the convention is not in force. Why? Because member states are not willing to enforce that convention. The idea is to improving the protection of environment at the European level by using criminal law. It seeks to harmonize national legislation in this field. It establishes as criminal offense a number of acts committed intentionally and through negligence. Not serious negligence, but only negligence. And to summarize this part of the presentation, in those directives, there are the lack of legal certainty may be also the weakness of this conference, because that they define what constitutes the crime by reference to the behavior of being under different directives of the European Union. So it's a crime by reference. Whoever kills another person should be punished by imprisonment for 10 years, 20 years, 100 years, 1,000 years. You have not by reference a crime. Explicitly, the structure chosen implies that the definition is by reference, and it is in implementation very difficult to determine which behavior constitutes environmental crime. You should ask a very law official telling, is this a crime or not? The attorney is asking someone, is this a crime or not? The structure of the convention, 1998, it's better because the behavior that has to be criminalized is described in a more direct manner, but it is not enforced. So there is not exist. Interpol General Assembly passed the resolution of Interpol response, and there while not defining environmental crime, there is saying that the focus of their interest is environmental security, and environmental security can harm the national political stability, environmental quality, natural resources, biodiversity, and so on. National legislature have addressed environmental exploitation through more or less comprehensive networks of administrative law. National laws have made regulation as to the extent of the permissible pollution or acceptable risk. So your pollution is permissible up to a certain level and not permissible in another field. It seems like 007 license to kill. He has the license to kill for a government. If he is behaving not in a good manner, he will receive a disciplinary sanction for 2 months, and afterwards he will be embedded back in Her Majesty's service. So everybody is happy afterwards. So there is a strong link between administrative law and criminal law. There is definitely a need for a more active role of the judiciary, which in case of Croatia is not existing, or almost not existing. Here it's a part of the criminal code, Croatian criminal code. There is a part dealing with criminal acts against the environment. There are some roughly 20 items. It seems to be a very good framework. The problem is the implementation. At the very beginning, we have the crimes of environment, a general provision. The first of provision is discharging of polluting substances from vessel. You always mean when there is a polluting or see that there is a sea by the main polluter is a ship, which in fact it is not. Then endangering environmental with waste, industrial plant, noise, vibration, protected natural areas, destroying habitat, and so on. Here we can find water regime, illegal construction. Illegal construction is an environmental crime in the Republic of Croatia. how many illegal construction you have on coastal zone. Is there any crime, environmental crime, punishment? No environment. So, as you can see, there is no implementation. And here some statistical data. All statistical data are not accurate. that's the first remark. The second is that there is an obligation of the attorney to have a regular report to Sabor or to the parliament, telling what he's doing in the past year. And according to this report, we can see a number of data. Moreover, there are some data from the various inspections. They were firstly embedded in different ministries. Now there are special entities. No one actually knows who is in charge, and they are not delivering the information as there is obligation. Although there is obligation to deliver the data, and you just said, well, that they are not receiving regularly data from member states, so it's a diplomatic assets. Anyhow, just to show you a data, in 251 imprisonment, 1 in jail, over 100 in probation imprisonment, so not in jail, 12 fines, 5 community service in the kitchen, or I don't know where. Next year, a big improvement, a triple of punishment from 1 to 3. So politicians will be very happy because things are going well. 92 probation, 80 community service, next year 5 imprisonment, and so on. And it's almost impossible to find the new data. So I didn't want to make the new data because unreliable information. So the reason for low number of detecting and reported crime is that we are living in a perfect world, or there is insufficient activity of competent institutions whose task is detecting and reporting crimes. In practice, we have a case in Rijeka for Marišćina that the state attorney qualifies the crime endangering the environment by improper waste management with minor infringement. And the pollution is continuing, and there is no response of the state attorney. So to conclude, an offense is a crime only if the state decides to punish certain behavior through criminal law. It implies that the definition of environmental crime depends upon the violation of national legislation implementing the environmental acquis. Environmental crime is an emerging crime connected with transnational organized crime. Only few perpetrators are sentenced to jail. Sentences that are pronounced are often very light, and fines are negligible compared with the profit and gains. There is need to make a new framework which should be effective, efficient, and dissuasive way to achieve a proper implementation of environmental law. The directive of the European Union are not helping us at all in that sense. And environmental crime should be not seen to refer to infraction resulting in fines, but it is a serious crime. In my view, there should be a proper relationship between criminal law and non-criminal law enforcement avenue. There is definitely increase of environmental crimes that need a proper response of the government from administrative law enforcement and judicial authority. Key concept of environmental law need to be further harmonized and more consistently interpreted by the EU member state. I will call your attention that those were directives, not regulations. Normally, when we speak about security, we speak about regulation, not about directives, because they are implemented directly to member state, and in directive it leaves to member state to choose the way how to implement it. And as a last sentence, I am outlining that there is a need for a more active role of the judiciary, and they are not aware of the problem which is existing in the society. Okay.